All right. Have we crashed? We're not crashing, so we're starting up. Trump trial verdict watch day 2. The jury went into deliberations yesterday, and so we're going to follow along today. It could happen, might not happen, but I do want to go over the jury instructions that Judge Mershon gave the jury. They seem to be a little ridiculous. Ridiculous to me. In the upper left-hand corner there, we have the live feed of the courthouse. And in the middle here, we have tweets from Inner City Press. He has covered it magnificently. So, without further ado, Justice Mershon says, "Get the jury, please." The jury enters. And Justice Mershon: "Jurors, I will now instruct you on the law. You will not receive copies. I can read them back to you. If you have come to believe that I have an opinion of this case, put it out of your mind." Never heard an instruction like that? Onward. In your deliberations, you may not speculate about matters related to sentencing. If there is a verdict of guilty, it will be my responsibility to impose sentence. Testimony which was stricken for the record must be disregarded by you. If you wake up and it's not raining but the street is wet, you may draw the inference that it rained overnight. On redactions, you may not draw any conclusion about why it is redacted or what is redacted. How's it going, everybody? Just getting in here. Am I reading? I'm reading to the void. No, I'm kidding. How's it going? Chat, let me know what's up. What do you want to do while we're waiting for this verdict to come in? All right. Justice Mershon. Here are some of the limiting instructions I gave you that AMI entered, a conciliation agreement and a non-prosecution agreement. You may not consider that as evidence that the defendant committed a crime. Some exhibits were admitted with a limiting instruction. If you have any questions, just send me a note, whatever your verdict may be. Let me get some music on the loop here. Otherwise, these next few hours, we could be waiting all day for a verdict. We could be waiting for an hour. I do not know how this is going to go. No one knows. All right. Well, maybe not. Maybe not no one. It could, the whole thing could be rigged, right? Chat, I don't know. All right. The exhibits next. You may ask, did the witness have a conscious bias? You may consider if a witness had or did not have a motive to lie. You are not required to reject the testimony of an interested witness. Under our law, Michael Cohen is an accomplice. A defendant may not be convicted of the testimony of an accomplice unless it is corroborated by other evidence. The offense is falsifying business records in the first degree, 34 counts. Under our law, a person is guilty of this when, with intent to defraud, with the intent to commit another crime, that person causes the entry of a false business record. Intent means conscious, objective, or purpose. All right. And let me just go ahead, chat, and throw a picture of the justice. Because it's kind of, you know, me giving the instructions, we can do better than that. Let's see how quickly we can pull up the justice. Mershon. Hey. I mean, he's a handsome man, but the fix is in, right? Bam! There he is. So that's who we're talking about. And where do we leave off? The first of the people's theories of unlawful means is federal elections law, including as to the office of the President of the United States. Under FECA, a corporation may not make a contribution to a candidate or an expenditure in concert with a candidate. If the payment would have been made absent the candidacy, it should not be treated as a contribution. There is an exemption for legitimate press functions. The second of the people's theories of unlawful means is to falsify other business records. So let's just pause here for a second, because it seems as though that this would have happened regardless of whether he was running for president or not. This seems to be the kind of thing that you want to keep quiet. You don't want your family and your wife to find out. This is what I've heard. This is the theory that I've heard, okay? So people's theory number one doesn't really, it's, you know, built on sand. You may consider, for example, the 1099 issued to Michael Cohen and his other paperwork. The third theory is violation of tax law. Even if it does not result in any underpayment of taxes, we start with the invoice of Michael Cohen in February 2017. If that's what they get him on, man, how could that? The government is so dirty. That's all I'll say. You know, when they want you, they're going to get you. It's hard to argue against that. Gary, welcome. The People's Republic of Maine, run by fruits and nuts. Dude, New England, well, not as bad as Connecticut, right? They got, is that Rosa DeLauro? She looks like something out of a fairy tale, not in a good way. Who do you got there? Show me the man and I'll show you the crime. All right, Kendall. This justice is something else. Get your allegedly mug, Dave the lawyer, Shopify. I'm supposed to do a better job at that kind of thing. I am trying to YouTube it, a little bit. I'm watching other lawyers. They're so much better. They're so... I don't know if I'm built for the sales pitch aspect. Okay. So, Mershon. There are 33 other counts. The only difference is that each count concerns a different business record, possibly a different date. The 34th count pertains to December 5th, 2017. Section 15152 of New York election law concerns promoting or preventing. That's where it cut off there. The next one was, if you find the people have proven the elements beyond a reasonable doubt, you must find the defendant guilty. Motive is the reason why the person chooses to engage in criminal conduct. Motive is not an element of the crimes charged. And so, just chat, let you know that these are tweets, so they're not perfect, one-to-one representations of what happened in the courtroom. But Inner City Press did a damn good job. I mean, you're not getting this kind of coverage anywhere else. Not live tweeting. Not like this. Not like this. You get everybody's opinion. What happened next? This is straight up what was happening in the courtroom, which is not what they want you to know. An appeal to heaven. Okay, yeah. Dug up dandies. I saw Mike Lee tweeting that. What's that about? Let me know in the chat. I don't know. It's been a hard one to follow, and I mean by a hard 90 something across several different cases, and they did this on purpose. By the way, read somewhere yesterday that Judge Mershon drew 3 Trump cases. Not Trump necessarily, but I think Bannon and someone else, and those chances of him drawing all 3 organically, 1 in 15,000. He might want to play the lotto. They don't even have to agree on each crime, just 1 of 3. So we're getting to that instruction too, the 4x4x4 instruction. I think we're coming up on that. Coming up. I think. All right. So, your verdict must be unanimous. You must deliberate, discuss, consult, listen, reason together when considering the evidence. You should not hesitate to change your vote if you're convinced. Some took notes. They are only for you. Let me just go ahead and mute the feed up there of what's going on outside the courtroom, just in case they play some ad or some music. It's going to knock us out. All right. Can you tell that my espresso is kicking in? Listen, this channel is run on espresso. Just bear with me here. If you want testimony read back, ask me. Stricken record testimony will not be read back. Under our law, the first juror selected is the foreperson who transmits notes to the court. When there is a verdict, the jurors will come back here. I will give you a verdict sheet. While you are deliberating, you will be kept together in a jury room. Lunch will be provided. Give your cell phone to the court officers while you are deliberating. The plan is to work today to 4:30. And that was yesterday. That concludes my instructions. So wait, where's the infamous 4x4 instructions? Juror, there's a laptop with the evidence on it. Jurors 4 and 6 will be shown how to operate it. Step out with the 6 alternates stepping to the side. Every one of you was very engaged. Alternate 3, you went through 3 notebooks, I think. We are not releasing you yet. You may be needed. Hand in your cell phones. Follow the court officers. Let's bring jurors 4 and 6 who volunteered for the laptop in to show them how to operate it. Mr. Blanche, has your client consented to sending the laptop back? Trump's lawyer Blanche, yes. Okay. And we have Matthew Russell Lee. If you want to donate, I suggest doing it. Jury note, alert on the move. Okay. The request is for David Pecker's testimony about the phone conversation with the defendant about the decision not to finalize Karen McDougal's life rights. So where is that 4x4 testimony? The instructions are sometimes buried. It's so annoying. And these strings. So let's see if we can just find it. Instruction 4. Right. Inner City Press. What's going on, chat? Oh boy, Gary. I have thoughts on that. Interesting. Okay. He might not have caught it. I don't believe that for a minute, because he caught everything. Just in case he didn't catch it. I believe that instruction was crazy. It says that, okay, assuming that Rick and Beans is a legal authority here, 4x4 jury instruction. Okay, that's not helpful. Yeah. So, let's find it, though. We're here to dig in. If we go to tools, anytime past 24 hours. Mershon. Okay. Here we are with the AP. Are you following, chat? I hope you are. Come on in. The claim, New York Judge Juan Mershon told the jury in former President Trump's hush money trial that they don't need a unanimous verdict to convict Trump. Okay. And so this is like they're disputing this. Maybe it wasn't said, maybe it was deleted, maybe it was misunderstood. I've seen it for sure, right, chat? And I didn't see it in an Inner City Press, so you got to take it with a grain of salt. Got to take it with a grain of salt. The Trump jury will have to find unanimously on each of the 34 counts that he falsified business records and that he did so with the intent of concealing another crime, the case violating a state election law during his 2016 campaign. The judge said jurors could consider 3 different ways the law may have been broken, and they don't have to be unanimous on this decision. As the jury deliberations began Wednesday in the Trump trial, social media users spread false information. Look, I definitely, I heard it somewhere else with some authority. It could have been Frey. Viva. Viva. I'm new, okay? I'm new to LawTube. LawTube, this is more like politics tube. How's this even a fair trial? Here's one Instagram post. The judge has announced the jury does not even have to be unanimous in their judgment to convict President Trump. This entire process was rigged from the start. Okay, this is closer to what I've seen. Judge Mershon has told the jury that they do not need unanimity to convict. They do not have to all agree on what occurred. 4 could agree on one crime, 4 could agree on another, and 4 on another. He will treat this 4-4-4 unanimously. But these claims distort Judge Mershon's instructions. Okay, here's what we're coming to. The judge told the jury that to convict Trump on any given charge, that they will have to find unanimously. That is, that all 12 jurors must agree that the former president created a fraudulent entry in his company's records or caused someone else to do it, and that he did so with the intent of committing or concealing a crime. Okay, so prosecutors say that Trump committed this. Okay, we know this part. Let me say this about what is very annoying about bad attorneys, is they give bad advice and it leads you down a road where this happens years later, okay? Been there. On the receiving end of bad advice. Get your allegedly mugs. And also I have Tears of Special Counsel. That one's a special one. I really enjoy drinking out of that one. All right. So let's just go back to Inner City Press and see what's going on here, guys. What are we missing? Because he is there, outside, inside, or where? Trump trial, jury deliberations, day 2, Pecker and Cohen, readbacks requested on Karen McDougal. So they wanted those that testimony read back to them. Trump Tower meeting and Jersey call. Okay, then. So Inner City Press has been putting out little booklets, and this is one of them, the Pecker's testimony. I just don't want to miss any of this thread. Trump is here, blue suit, blue tie, Todd Blanche smoothing his hair down, Bove not so much. A sheet of paper is passed down the line to Susan Nichols. All rise. This is the people of the state of New York against Donald J. Trump. I'm just going to click on each one of these just to make sure we're not missing a thing, because that's what happens, right? Justice Mershon. I read over the disputed area of readback. They will all come in. Anything on that? Prosecutor. Thank you, Judge. Trump's lawyer, Blanche. No. Justice Mershon. We received another jury note on jury instructions. They want page 7 through 35. Justice Mershon. Wait. 7 through 35. And they asked for headphones for use with the evidence laptop. I think we could give them speakers so call can hear. We can give them both. Let me put it on the record. The laptop does not have Wi-Fi. Let's get the jury, please. And we're up to date. That's it. That's where we are. Nothing going on. And so there's that little tree again. What is this tree, chat? I got it. They don't even have to agree. 4x4x4 instruction coming up. There was never a crime mentioned. I know. Something like that. Yes, there was. Would you be Trump's attorney? I would be. Absolutely. Lock Trump up. And here's why. Let me tell you something. I mean, the system seems to be stacked against him anyway. I would definitely... It's a tradition, a attorney tradition since Adams. You defend people regardless. Now, listen, I volunteered at the public defender's office, and some people I can't defend. I can't. The child stuff, I'm not defending that. This stuff, he directed his attorney, which there was no apparent direction that I've heard of. So basically what I'm trying to say is Michael Cohen is a bad guy. If you put another attorney in his position, things might have turned out, it would have turned out differently, right? I mean, confidences have been betrayed. He's recorded his clients when they were actively his clients to use it as blackmail against them. These are things that are mind-blowing. So it's insane. Yeah, I would defend him in a second against this. This is crazy. The FBI says hello. Tell Director Ray I said hello, and Paul Abadi, and please tell them that this is just, we're just streaming here. Nothing to see. No bad intention. This is just words. 91 indictments, baby. Man's a criminal. No, see, they invented 91 different things to charge him with. I could invent 91 different things to charge you with, then people would call you a criminal. That's kind of bullshit. Most definitely a political trial. Yeah, kangaroo court. Random, you have been fooled by the Democrats. Yeah. It's crazy. It's crazy. And especially when you have people like, what is it, Avenatti coming out and say, this even the gag order is crazy. This is crazy. This has been, to think that the pendulum's not going to swing back and no one's going to have to answer for anything is kind of insane too. In other countries, at least these people are ousted. I don't know that they should be jailed, judges and district attorneys and state attorneys. When the political pendulum swings back towards, the center, sometimes those judges and state attorneys and district attorneys, sometimes they are thrown out. And that's probably the best case scenario for the bad actors here. I don't know. Okay, so let's see. I think we're probably going to have something else going on now that a few minutes have passed. Now that I've ranted for a few minutes. No. Nothing to do. But I still would like to find out what this tree is all about that I keep seeing. So, appeal to... What is it? Remember when the mainstream media was honest? I think so, but it's hard to look back and remember when that was, because it seems like they may have been... Yeah, I don't know what the Tree of Liberty is all. This is the first time I've seen it. Yesterday, Mike Lee posted it, and that was the first time I saw it. Let me see if I can find that for y'all. Mike Lee. Based Mike Lee. What a great profile. The banner. Come on, Mike Lee. Okay. Please like and share if you considered Martha Alito a hero. Okay. Martha Ann Alito, an appeal to heaven. Is that the flag she flew? I don't know. There's so much going on right now. It's hard to follow. And I got, other lawyerly things that happen to be happening too. That are completely unrelated. The Tree of Liberty, an appeal to heaven flag. One of them, yes. All right. Let's find out what is going on. The appeal to heaven tree flag. All about. Okay, the appeal to heaven flag, also known as the pine tree flag, has historical significance dating back to the American Revolutionary War. Here's an overview of its background and symbolism. Historical context. Origin. The flag was first used by the Massachusetts Navy in 1775. The designer, it is believed that it was designed by George Washington. Didn't know that. Usage. It was flown on ships commissioned by the Massachusetts State Navy during the early stages of the American Revolution. Design. The flag typically features a white field with a green pine tree in the center, the motto, an appeal to heaven, inscribed above or below the tree. The pine tree symbol has historical significance in New England, particularly referencing the eastern white pine, which was highly valued for shipmasts. Interesting. Symbolism. The pine tree represents the natural resources of New England and the colonies' resistance to British exploitation of these resources. Appeal to heaven. This phrase is derived from writings of John Locke, specifically his theory of natural law. It implies that when all legal avenues are exhausted and justice cannot be obtained through human means, an appeal to a higher power or heaven is justified. That's kind of heavy. Revolutionary spirit. The flag encapsulated the colony's sentiment of seeking divine support in their quest for independence and justice against British tyranny. Modern usage. Libertarian and patriot groups in recent times, the flag has been adopted by various groups who emphasize the principles of liberty, resistance to tyranny, and appeal to a higher moral authority. Symbol of defiance. It remains a symbol of defiance against perceived governmental overreach and a call to fundamental natural rights. The appeal to heaven flag thus stands for a historical emblem of resistance, natural rights, and the quest for justice beyond conventional legal systems. Very cool. I want one. I like it. And then so she also hung an American flag upside down, which is just a sign of distress. Yeah. Did anybody see the movie Last Castle? That's the first time I saw the American flag hung upside down. Absolutely amazing movie. James Gandolfini, Mark Ruffalo before he became, Mark Ruffalo. Because America, the idea is in distress. What do you look for in man? I'm assuming simply is going to be asking someone else in the chat that. John Santos, thank you. Thank you, John Santos. What do I look for in a man? A Jordan Peterson-like slim figure, all bone and sinew, custom suit. And a nice watch. That's tell a lot about it. No, I'm just kidding. I don't know. Let's get back to Inner City Press. Inner City Press. Where you at? Okay, so the jury is entering. And let's see if there's anything above. Yeah. All right, so the last thing, allegedly, that happened was, you know, a laptop doesn't have Wi-Fi, speakers, and headphones to listen to evidence. Jury's entering. Judge Mershon. We have your notes. Rereads them. Let me know by note if you want headphones or speakers. Do you want the instructions or testimony first? Instructions, okay. Begins from page 6. And so, I don't know what we're getting here. I guess this is the instructions. Let's go for it, huh? Put that guy right over there. Page 6. When you judge the facts, you are to consider only the evidence. The evidence in the case includes the testimony of the witness, the exhibits that were received in evidence, and the stipulations agreed to by the parties. Remember, a stipulation is information the parties have agreed to present to the jury as evidence without calling a witness to testify. The testimony, which was stricken from the record to which an objection was sustained, must be disregarded by you. Exhibits that were received in evidence are available upon your request for your inspection and consideration. Exhibits that were just seen during trial or marked for identification but not received in evidence are not evidence and thus not available for your inspection and consideration. Let's see how we doing, chat. But testimony based on those exhibits that were not received in evidence may be considered by you. It is just that exhibit itself is not available for your inspection and consideration. Evidentiary inferences. In evaluating the evidence, you may consider any fact that is proven and any inference which may be drawn from such fact. To draw an inference means to infer, to find, to conclude that the fact exists or does not exist based on the proof of some other fact or facts. For example, suppose you go to bed one night and it is not raining, and when you wake up in the morning, you look out your window, you do not see rain, but you see that the street and sidewalk are wet, and that people are wearing raincoats and carrying umbrellas. Under those circumstances, it may be reasonable to infer, that is, conclude, that it rained during the night. In other words, the fact of it having rained while you were asleep is an inference that might be drawn from the proven facts of the presence of the water on the street and sidewalk, and people in raincoats carrying umbrellas. An inference must only be drawn from a proven fact or facts, and then only if the inference flows naturally, reasonably, and logically from the proven fact or facts. Not if it is speculative. Therefore, in deciding whether to draw an inference, you must look at and consider all the facts in light of reason, common sense, and experience. Follow in chat. Let's see. I like Luke. You don't have to agree that the defendant's guilt of any specific crime. Just make sure you all think a crime has been committed. Oh boy. Hey KJ, what's going on? All right, Santos. So I am intrigued to learn from your session. I believe now that this is going on real time. Thanks again. Yo, yeah, this is. I think we're right up to the second. I'm going to go back and forth between Inner City Press's Twitter feed. This is as much real time as it's gonna get, I think. Okay, wait, let me go back here. There we go. Now you got why is that on mute there? That's what's happening outside the courtroom in the way upper top live. I'm live down here. And then we're reading over in the middle, Inner City Press. He's in the courtroom. So just about as live as we can get. And jury enters, starts reading from page 6. And so he's probably still reading like we are. So we can just keep reading. Read actions. How many pages are we talking about here of instructions? Woo, 55 pages. Jury instructions and charges. But I don't know how long the instructions go until we get to the charges. Ooh, so many. It looks like charges. Okay, the charges. Okay, start on page 27. See if we can get to 26. As you know, certain exhibits were admitted into evidence with some portions blacked out or redacted. Those redactions were made to remove personal identifying information and to ensure that the only relevant admissible evidence was put before you. You may not speculate as to what material was redacted or why, and you may not draw any inference, favorable or unfavorable, against either party from the fact that certain material has been redacted. We know all about redactions, chat. If you were here for the what was it, Jeffrey Epstein and Ghislaine Maxwell, you know, we went over the stuff that was released there, and it was redaction town. Luke, here's what I'm gonna say. I have no thoughts. It's a sticky situation, and I wouldn't. I mean, there's so many law tubers covering it. I figured I'd go in the other direction. Been in similar circumstances. I mean, you know, everybody's different, but I wouldn't want every law tuber covering my. That's my position on it. You know, and it's unfortunate. I guess when you're a public guy, that's to be expected. But yeah, I don't know. Limiting instructions. You may recall that I instructed you several times during the trial that certain exhibits were being accepted into evidence for a limited purpose only, and that you were not to consider that evidence for any other purpose. Under the law, we refer to that as a limiting instruction. I will now remind you of some of the limiting instructions you were given during the trial. AMI. You will recall that you heard testimony from David Pecker, was an executive at AMI. AMI entered into a non-prosecution agreement with federal prosecutors, as well as a conciliation agreement with the Federal Election Commission. I remind you that evidence was permitted to assist you, the jury, in assessing David Pecker's credibility and to help provide context for some of the surrounding events. You may not consider that testimony. You may consider that testimony for those purposes only. Neither the non-prosecution agreement nor the conciliation agreement is evidence of the defendant's guilt, and you may not consider them in determining whether the defendant is guilty or not guilty of the charged crimes. Michael Cohen. You also heard testimony that the Federal Election Commission conducted an investigation into the payment to Stormy Daniels and of responses submitted by Michael Cohen and his attorney to the investigation. That evidence was permitted to assist you, the jury, in assessing Michael Cohen's credibility and to provide context for some of the surrounding events. That's a joke. Zero credibility. You may consider that evidence for those purposes only. Likewise, you will recall that you heard testimony that Michael Cohen pleaded guilty to violating the Federal Election Campaign Act, otherwise known as FECA. I remind you that evidence was permitted to assist you, the jury, in assessing Mr. Cohen's credibility as a witness and to help provide context for some of the events that followed. You may consider the testimony for those purposes only. Neither the fact of the FEC investigation, Mr. Cohen, and his attorney's responses, or the fact that Mr. Cohen pleaded guilty constitutes evidence of the defendant's guilt, and you may not consider them in determining whether the defendant is guilty or not guilty of the charged crimes. All right, we're going to take a peek at Inner City Press's feed and see if we're back to any action. It looks like Judge Mershon is still reading, perchance. And another thing, gosh, he's just surrounded himself with so many bad attorneys. So in this trial, it's pretty clear Michael Cohen is you know, I don't know if he was ever really an attorney. He called himself one, but whoo. When you get to the point where you're recording your clients, I don't know. It's time to just make a move. Different sector, different line of work maybe. But you'd also look at what happened in Fulton County. You know, attorneys like Jenna Ellis crumbled under the smallest amount of scrutiny. Blubbering. I'm so sorry. Please don't. Like, oh. The dogs agree. I closed the door. They're probably going to keep going, but all right. Yeah. So you had, you know, Jenna Ellis is another not great attorney that bubbled to the surface during this one. You have Mr. Cohen is, you know, not a great attorney. So you can't help but think, God, I could have done such a better job. Definitely in Fulton County. And, you know, anybody can do a better job than Cohen did. You just need some sort of, you know, moral compass. That's it, really. Yeah. The dogs are good dogs. They're good dogs. They're good boys. I will say this. One of them is a Rhodesian Ridgeback. And before I got him, I did research. And one of the things research showed was that they're very sensitive dogs. And I don't know, how is a dog sensitive? What does that mean? Well, I don't know how to describe it, but it's 100% right. He's a sensitive dog. You know? He's a sensitive boy. And if we're not back live here with Inner City Press, we can go ahead and just continue onward with the instructions. This is what they're hearing in the courtroom right now. Wall Street Journal news articles. You will recall that certain Wall Street Journal news articles were accepted into evidence during the trial. I remind you now that the articles were accepted and may be considered by you for the limited purpose of demonstrating that the articles were published on or about the certain date and to provide context for the other evidence. The exhibits may not be considered by you as evidence that any of the assertions in the articles is true. It's a weird one. There were other exhibits in which contained hearsay and were not accepted into evidence for the truth of the matter asserted, but for another purpose. For example, there were several National Enquirer headlines and an invoice from the Investor Advisory Services. Those were accepted for the limited purpose of demonstrating that the articles were published in the document and the document created. There were also some text messages that were accepted with a similar limitation. For example, People's Exhibit 171A with the respect to Gina Rodriguez's text only, and 257 with respect to Chris Cuomo's texts only. Those text messages were accepted for the limited purpose of providing context for the responses by Dylan Howard and Michael Cohen. The exhibits which were accepted into evidence with the limiting instruction are 152, 153A, 153B, 153C, 161, 171, 180, 181, and 257. If you have any additional questions or need clarification as to which exhibits were accepted into evidence with limitations, just send me a note with your question and I will be happy to clarify. Presumption of innocence. We now turn to the fundamental principle of our law that apply in all criminal trials, the presumption of innocence, the burden of proof, and the requirement of proof beyond a reasonable doubt. Throughout these proceedings, the defendant is presumed to be innocent. As a result, you must find the defendant not guilty unless, on the evidence presented at this trial, you conclude that the people have proven the defendant guilty beyond a reasonable doubt. I do not think so. Based on Inner City Press's tweetings and all that, I don't think they've proven anything beyond a reasonable doubt. In determining, except for Michael Cohen, you know, and his what's the word? Is there with the chat, if you have a really good word to describe Cohen? His character or lack thereof is what comes to mind. In determining whether the people have satisfied their burden of proving the defendant's guilt beyond a reasonable doubt, you may consider all of the evidence presented, whether by the people or by the defendant. In doing so, however, remember that even though the defendant introduced evidence, the burden of proof remains on the people. Defendant did not testify. The fact that the defendant did not testify is not a factor from which any inference unfavorable to the defendant may be drawn. Burden of proof. The defendant is not required to prove that he is not guilty. In fact, the defendant is not required to prove or disprove anything. To the contrary, the people have the burden of proving the defendant guilty beyond a reasonable doubt. That means, before you can find the defendant guilty of a crime, the people must prove beyond a reasonable doubt every element of the crime, including that the defendant is the person who committed the crime. That crime. The burden of proof never shifts from the people to the defendant. If the people fail to satisfy their burden of proof, you must find the defendant not guilty. And if the people satisfy their burden of proof, you must find the defendant guilty. Reasonable doubt. What does our law mean when it requires proof of guilt beyond a reasonable doubt? Before we get into this instruction here, just want to check Inner City Press to see if anything has happened since he's begun reading instructions. And it doesn't look like it, unless I'm just going to refresh and make sure here. 17 minutes, and we are still current, gang. All right. The law uses the term proof beyond a reasonable doubt to tell you how convincing the evidence of guilt must be to permit a verdict of guilty. How we doing, chat? The law recognizes that in dealing with human affairs, there are few things in this world that we know with absolute certainty. Therefore, the law does not require the people to prove the defendant beyond all possible doubt. On the other hand, it is not sufficient to prove that the defendant is probably guilty. In a criminal case, the proof of guilt must be stronger than that. It must be beyond a reasonable doubt. A reasonable doubt is an honest doubt of the defendant's guilt, for which a reason exists based upon the nature and quality of the evidence. It is an actual doubt, not an imaginary doubt. It is a doubt that as a reasonable person acting in a manner of this importance would be likely to entertain because of the evidence that was presented or because of the lack of convincing evidence. Proof of guilt beyond a reasonable doubt is proof that leaves you so firmly convinced of the defendant's guilt that you have no reasonable doubt of the existence of any element of the crime or of the defendant's identity as the person who committed the crime. I know, it's funny because you think that they should prove, they would find Cohen guilty, but I think part of the instructions were you can't go there. This is about Trump, not Cohen. In determining whether the people have proven the defendant's guilt beyond a reasonable doubt, you should be guided solely by a full and fair evaluation of the evidence. After carefully evaluating the evidence, each of you must decide whether that evidence convinces you beyond a reasonable doubt of the defendant's guilt. Whatever your verdict may be, it must not rest upon baseless speculation, nor may it be influenced in any way by bias, prejudice, sympathy, or by a desire to bring an end to your deliberations or to avoid an unpleasant duty. If you are not convinced beyond a reasonable doubt that the defendant is guilty of a charged crime, you must find the defendant not guilty of that crime. And if you are convinced beyond a reasonable doubt and the defendant is guilty of a charged crime, you must find the defendant guilty of that crime. It's starting to feel like 1984. It's just starting to feel like 1984, Stacy. It started feeling like 1984 for me about at least a year ago. Yeah. Okay, and just checking on Inner City Press because he is live, and like literally live in the courtroom there. But it looks like they're still reading these instructions. Credibility of witnesses. Introduction. As judges of the facts, you alone determine the truthfulness and accuracy of the testimony of each witness. You must decide whether a witness told the truth and was accurate or instead testified falsely or was mistaken. You must also decide what importance to give to the testimony. You must also decide the importance. You accept as truthful and accurate. It is the quality of the testimony that is controlling, not the number of witnesses who testify, except in whole or in part. Falsus in uno. If you find that any witness has intentionally testified falsely as to any material fact, you may disregard that witness's entire testimony, or you may disregard so much of it as you find was untruthful, and accept so much of it as you find to have been truthful and accurate. Credibility factors. There is no particular formula for evaluating the truthfulness and accuracy of another person's statement or testimony. You bring to this process all of your varied experiences. In life, you frequently decide the truthfulness and accuracy of statements made to you by other people. The same factors used to make those decisions should be used in this case when evaluating the testimony. In general, some of the factors you may wish to consider in evaluating the testimony of a witness are as follows. Did the witness have an opportunity to see or hear events about which he or she testified? Did the witness have the ability to recall those events accurately? Was the testimony of the witness plausible and likely to be true, or was it implausible and not likely to be true? Was the testimony of the witness consistent or inconsistent with other testimony or evidence in the case? Did the manner in which the witness testified reflect upon the truthfulness of that witness's testimony? To what extent, if any, did the witness's background and training, education, or experience affect the believability of that witness's testimony? Did the witness have a conscious bias, hostility, or some other attitude that affected the truthfulness of the witness's testimony? It is really hard to read this with a straight face because, it's known around the world that Michael Cohen has some sort of bias and hostility towards Trump. Did the witness show an unconscious bias? That is, a bias that the witness may have even unknowingly acquired from stereotypes and attitudes about people or groups of people? And if so, did that unconscious bias impact that witness's ability to be truthful and accurate? Motive. You may consider whether a witness had or did not have a motive to lie. If a witness had a motive to lie, you may consider whether and to what extent, if any, that motive affected the truthfulness of that witness's testimony. If a witness did not have a motive to lie, you may consider that as well in evaluating the witness's truthfulness. Benefit. You may consider whether a witness hopes for or expects to receive a benefit for testifying. If so, you may consider whether and to what extent it affected the truthfulness of the witness's testimony. How's it going, chat? Smash the like. It's kind of hidden up there, and there's 3 dots, and then you gotta hit the like. It's not the hearts. I know, it's weird. They gotta fix that. YouTube, I know you're not watching. And subscribe, why not? Interest, lack of interest. You may consider whether a witness has an interest in the outcome of the case. Instead, whether the witness has no such interest. You are not required to reject the testimony of an interested witness or to accept the testimony of a witness who has no interest in the outcome of the case. You may, however, consider whether an interest in the outcome or the lack of such interest affected the truthfulness of the witness's testimony. Previous criminal conduct. You may consider whether a witness has been convicted of a crime or has engaged in criminal conduct, and if so, whether and to what extent it affects your evaluation of the truthfulness of that witness's testimony. You are not required to reject the testimony of a witness who has been convicted of a crime or has engaged in criminal conduct, or to accept the testimony of a witness who has not. You may, however, consider whether a witness's criminal conviction or conduct has affected the truthfulness of the witness's testimony. And we're barreling down on the end of the instructions here, chat. Inconsistent statements. You may consider whether a witness made statements at this trial that are inconsistent with each other. You may also consider whether a witness made previous statements that are inconsistent with his or her testimony at trial. You may consider whether a witness testified to a fact here at trial that the witness omitted to state at a prior time, when in fact it would have been reasonable and logical for the witness to have stated the fact. In determining whether it would have been reasonable and logical for the witness to have stated the omitted fact, you may consider whether the witness's attention was called to the matter and whether the witness was specifically asked about it. If a witness has made such inconsistent statements or omissions, you may consider whether and to what extent they affected the truthfulness or accuracy of the witness's testimony here at this trial. The contents of a prior inconsistent statement are not proof of what happened. You may use evidence of a prior inconsistent statement only to evaluate the truthfulness or accuracy of the witness's testimony here at trial. Consistency. You may consider whether a witness's testimony is consistent with the testimony of other witnesses or with other evidence in the case. If there were inconsistencies by or among witnesses, you may consider whether they were significant inconsistencies related to important facts, or instead were the kind of minor inconsistencies that one might expect from multiple witnesses to the same event. Witness pretrial preparation. You have heard testimony about the prosecution and defense counsel speaking to a witness about the case before the witness testified at this trial. The law permits the prosecution and defense counsel to speak to a witness about the case before the witness testifies, and permits a prosecutor and defense counsel to review with the witness the questions that will or may be asked at trial, including the questions that may be asked on cross-examination. You have also heard testimony that a witness read or reviewed certain materials pertaining to this case before the witness testified at trial. The law permits a witness to do so. Speaking to a witness about his or her testimony and permitting the witness to review materials pertaining to the case before the witness testifies is a normal part of preparing for a trial. It is not improper as long as it is not suggested that the witness depart from the truth. Identification. The people have the burden of proving beyond a reasonable doubt not only that a charged crime was committed, but that the defendant is the person who committed that crime. Thus, even if you are convinced beyond a reasonable doubt that a charged crime was committed by someone, you cannot convict the defendant of that crime unless you are also convinced beyond a reasonable doubt that he is the person who committed that crime. Accomplice as a matter of law. Under our law, Michael Cohen is an accomplice because there is evidence that he participated in a crime based upon conduct involved in the allegations here against the defendant. Our law is especially concerned about the testimony of an accomplice who implicates another in the commission of a crime, particularly when the accomplice has received, expects, or hopes for a benefit in return for his testimony. Therefore, our law provides that a defendant may not be convicted of any crime upon the testimony of an accomplice unless it is supported by corroborative evidence tending to connect the defendant with the commission of that crime. In other words, even if you find the testimony of Michael Cohen to be believable, you may not convict the defendant solely upon that testimony unless you also find that it was corroborated by other evidence tending to connect the defendant with the commission of the crime. The corroborative evidence need not by itself prove that a crime was committed or that the defendant is guilty. What the law requires is that there be evidence that it tends to connect the defendant with the commission of the crime charged in such a way as may reasonably satisfy you that the accomplice is telling the truth about the defendant's participation in that crime. In determining whether there is the necessary corroboration, you may consider whether there is material believable evidence as part of the testimony of Michael Cohen, apart from the testimony of Michael Cohen, which itself tends to connect the defendant with the commission of the crime. You may also consider whether there is material believable evidence apart from the testimony of Michael Cohen, which, while it does not itself tend to connect the defendant with the commission of the crime charge, it nonetheless so harmonizes with the narrative of the accomplice as to satisfy you that the accomplice is telling the truth about the defendant's participation in the crime and thereby tends to connect the defendant to the commission of the crime. And now here is where they get to the charged crimes, and this is a good time to go back and see what's going on with Inner City Press, because he is live and in the courtroom. What a Chad. Okay. Justice Mershon, 20 minutes into reading, has moved from page 6 to page 25 of his jury instruction, which is exactly where we left off, I think, maybe 24. Yeah, okay. We're right there in the courtroom. Unclear why a written copy of the instructions and of the upcoming testimony read back couldn't be given in writing to the jurors. That was a question I had too. And once again, we are right up to date. And, we let a little bit of time pass. We chat here together. We have a good time. Any questions, chat? There's something I've been wanting to do, which was play around with my Westlaw subscription. A lot of people know, and I used it here today to answer the question about the pine tree flag. ChatGPT is probably the most popular AI in the world. But for lawyers, we have something. Westlaw made their own AI. They connected it to their whole database, and it's kind of like having a junior associate work for you that doesn't complain. Just kidding. The judge should have been disbarred and charged for being so biased and dishonest. It's not their fault. The jury can't read. Okay. Funny, chat, funny. Yeah, so there is some weird connections to the judge, his daughter, and the DNC, right? That is not in my imagination. The dogs agree. So we can go onward with the instructions and the charged crimes, because Inner City Press is still doing its thing. Leave Mershon right there. Go back here. Okay, the charged crimes. I will now instruct you on the law applicable to the charged offenses. The offense is falsifying business records in the first degree. 34 counts. Accessorial liability. Our law recognizes that two or more individuals can act jointly to commit a crime, and that in certain circumstances each could be held criminally liable for the acts of the others. In that situation, those persons can be said to be acting in concert with each other. Our law defines the circumstances under which one person may be criminally liable for the conduct of another. That definition is as follows. When one person engages in conduct which constitutes an offense, another is criminally liable for such conduct when acting with the state of mind required for the commission of that offense. He or she solicits, requests, commands, importunes, or intentionally aids such person to engage in such conduct. Under that definition, mere presence at the scene of a crime, even with knowledge that the crime is taking place or mere association with a perpetrator of a crime does not by itself make a defendant criminally liable for that crime. In order for the defendant to be held criminally liable for the conduct of another, which constitutes an offense, you must find beyond a reasonable doubt that he solicited, requested, commanded, importuned, or intentionally aided that person to engage in that conduct, and that he did so with the state of mind required to commission the offense. If it's proven beyond a reasonable doubt that a defendant is criminally liable for the conduct of another, the extent or degree of the defendant's participation in the crime does not matter. A defendant proven beyond a reasonable doubt to be criminally liable for the conduct of another in the commission of a crime is as guilty of the crime as if the defendant personally had committed every act constituting the crime. The people have the burden of proving beyond a reasonable doubt that the defendant acted with the state of mind required for the commission of the crime, and either personally or by acting in concert with another person committed each of the remaining elements of the crime. Your verdict on each count you consider, whether guilty or not guilty, must be unanimous. In order to find the defendant guilty, however, you need not be unanimous on whether the defendant committed the crime personally or by acting in concert with another or both. That's a weird one, right? That's I don't think we have a verdict. So what happened was, the jury was called in this morning and the judge read to them the instructions again. We were just going through them. You can go back about 10, 15 minutes. I think we were page 6 through 25 or 24 were the instructions that the jury just got them. So we should be right up to date. I keep refreshing Inner City Press because he knows this stuff before we know it. And it doesn't look like anything has happened since the instructions have been read. It doesn't look like it. It doesn't look like it. The blue wave people are out in masses today. Yeah, so we're really, really up to date is what it looks like here. And so we can just keep going, put ourselves in the shoes of the jury. This is what they're hearing. This is what they're going through. I will now instruct you on the law applicable to the charged offense. The offense is falsifying business records in the first degree. 34 counts. It's curious. Ugh. Yeah, I don't know, chat. I'm not. Look, we've done this before on this stream, okay? And I want to have my voice tomorrow. I can, maybe, perchance. I have an idea. Bear with me. Let's see if we can make this happen. We'll go to the charged crimes and the under our law person is guilty, right? See if we can get my computer. Did we do the? Okay, the tax. We're gonna go up into the tax. Right here is a good place to see if we can get this going. Text allowed. No. Read aloud. What is my application that does this for me? There it is. So, new article, paste, and then we're going to have Sally read it to us.
The charged crimes. I will now instruct you on the law applicable to the charged offense. That offense is falsifying business records in the first degree. 34 counts. Falsifying business records in the first degree penal law, section 175.10 under our law. A person is guilty of falsifying business records in the first degree when, with intent to defraud, that includes an intent to commit another crime or to aid or conceal the commission thereof. That person makes or causes a false entry in the business records of an enterprise. The following terms used in that definition have a special meaning. Enterprise means any entity of one or more persons, corporate or otherwise, public or private, engaged in business, commercial, professional, industrial, social, political or governmental activity. Business record means any writing or article, including computer data or computer program, kept or maintained by an enterprise for the purpose of evidencing or reflecting its condition or activity. Page 28. Intent means conscious objective or purpose. Thus, a person acts with intent to defraud when his or her conscious objective or purpose is to do so. Intent does not require premeditation. In other words, intent does not require advanced planning. Nor is it necessary that the intent be in a person's mind for any particular period of time. The intent can be formed, and need only exist, at the very moment the person engages in prohibited conduct or acts to cause the prohibited result, and not at any earlier time. The question naturally arises as to how to determine whether a defendant had the intent required for the commission of a crime. To make that determination in this case, you must decide if the required intent can be inferred beyond a reasonable doubt from the proven facts. In doing so, you may consider the person's conduct and all of the circumstances surrounding that conduct, including, but not limited to, the following. What, if anything, did the person do or say? What result, if any, followed the person's conduct? And was that result the natural, necessary, and probable consequence of that conduct? Therefore, in this case, from the facts you find to have been proven, decide whether you can infer beyond a reasonable doubt that the defendant had the intent required for the commission of this crime. Page 29. Intent to defraud. As I previously explained, a person acts with intent to defraud when his or her conscious objective or purpose is to do so. In order to prove an intent to defraud, the people need not prove that the defendant acted with the intent to defraud any particular person or entity. A general intent to defraud any person or entity suffices. Intent to defraud is also not constricted to an intent to deprive another of property or money and can extend beyond economic concerns. Intent to commit or conceal another crime. For the crime of falsifying business records in the first degree, the intent to defraud must include an intent to commit another crime or to aid or conceal the commission thereof. Under our law, although the people must prove an intent to commit another crime or to aid or conceal the commission thereof, they need not prove that the other crime was in fact committed, aided, or concealed. Page 30. New York Election Law, Section 17 to 152. Predicate the people allege that the other crime the defendant intended to commit, aid, or conceal is a violation of New York Election Law, Section 17 to 152. Section 17 to 152 of the New York Election Law provides that any two or more persons who conspire to promote or prevent the election of any person to a public office by unlawful means and which conspiracy is acted upon by one or more of the parties thereto, shall be guilty of conspiracy to promote or prevent an election. Under our law, a person is guilty of such a conspiracy when, with intent that conduct be performed that would promote or prevent the election of a person to public office by unlawful means, he or she agrees with one or more persons to engage in or cause the performance of such conduct. Knowledge of a conspiracy does not by itself make the defendant a co-conspirator. The defendant must intend that conduct be performed that would promote or prevent the election of a person to public office by unlawful means. Intent means conscious objective or purpose. Thus, a person acts with the intent that conduct be performed that would promote or prevent the election of a person to public office by unlawful means when his or her conscious objective or purpose is that such conduct be performed. Evidence that defendant was present when others agreed to engage in the performance of a crime does not by itself show that he personally agreed to engage in the conspiracy. Page 31. By unlawful means, although you must conclude unanimously that the defendant conspired to promote or prevent the election of any person to a public office by unlawful means, you need not be unanimous as to what those unlawful means were. In determining whether the defendant conspired to promote or prevent the election of any person to a public office by unlawful means, you may consider the following. 1. Violations of the Federal Election Campaign Act, otherwise known as FECA. 2. The falsification of other business records. Or 3. Violation of tax laws. The Federal Election Campaign Act. The first of the people's theories of unlawful means which I will now define for you is the Federal Election Campaign Act. Under the Federal Election Campaign Act, it is unlawful for an individual to willfully make a contribution to any candidate with respect to any election for federal office, including the office of President of the United States, which exceeds a certain limit. In 2015 and 2016, that limit was $2,700. It is also unlawful under the Federal Election Campaign Act for any corporation to willfully make a contribution of any amount to a candidate or candidate's campaign in connection with any federal election.
Gang, because there's some more action on Inner City Press's Twitter feed. Let's get as about current as we can. I thought there was something here. Yes, okay. Justice Mershon. Now we will do the readbacks. Reader 1. Did you ever come to believe that Michael Cohen had spoken with Donald Trump about Miss McDougal? Reader 2. Playing Pecker. Yes. And so there is a whole book that Inner City Press did on Pecker. Summary. Let's just see. Reader 1 asks about Cohen discussing Trump and McDougal. Thank you, Summarize. Okay, we can go back, I guess. Waiting for the jury to get read in on all the questions that they had this morning. So, let's get back over here and resume.
Election, or for any person to cause such a corporate contribution. For purposes of these prohibitions, an expenditure made in cooperation, consultation, or concert with, or at the request or suggestion of, a candidate or his agents shall be considered to be a contribution to such candidate. Page 32. The terms contribution and expenditure include anything of value, including any purchase, payment, loan, or advance, made by any person for the purpose of influencing any election for federal office. Under federal law, a third party's payment of a candidate's expenses is deemed to be a contribution to the candidate unless the payment would have been made irrespective of the candidacy. If the payment would have been made even in the absence of the candidacy, the payment should not be treated as a contribution. FECA's definitions of contribution and expenditure do not include any cost incurred in covering or carrying a news story, commentary, or editorial by a magazine, periodical publication, or similar press entity, so long as such activity is a normal, legitimate press function. This is called the press exemption. For example, the term legitimate press function includes solicitation letters seeking new subscribers to a publication. Falsification of other business records. The second of the people's theories of unlawful means which I will define for you now is the falsification of other business records. Under New York law, a person is guilty of falsifying business records in the second degree when with intent to defraud, he or she makes or causes a false entry in the business records of an enterprise. Page 33. I previously defined for you the terms enterprise, business records, and intent to defraud. For purposes of determining whether falsifying business records in the second degree was an unlawful means used by a conspiracy to promote or prevent an election here, you may consider I. The bank records associated with Michael Cohen's account formation paperwork for Resolution Consultants LLC and Essential Consultants LLC accounts. 2. The bank records associated with Michael Cohen's wire to Keith Davidson. 3. The invoice from Investor Advisory Services Incorporated to Resolution Consultants LLC. And 4. The 1,099 miscellaneous forms that the Trump Organization issued to Michael Cohen.
We can move on to the violation of tax laws next. That was sort of successful. That little read back. And let's go here. And speak to me.
Violation of tax laws.
Who invited Microsoft David in here, huh?
Laws. The people's third theory of unlawful means, which I will define for you now, is a violation of tax laws. Under New York State and New York City law, it is unlawful to knowingly supply or submit materially false or fraudulent information in connection with any tax return. Likewise, under federal law, it is unlawful for a person to willfully make any tax return, statement, or other document that is fraudulent or false as to any material matter, or that the person does not believe to be true and correct as to every material matter. Under these federal, state, and local laws, such conduct is unlawful even if it does not result in underpayment of taxes. Count specific. In order for you to find the defendant guilty of the crime of falsifying business records in the first degree under count 1 of the indictment, the people are required to prove, from all of the evidence in the case, beyond a reasonable doubt, each of the following 2 elements. 1. That on or about February 14, 2017, in the county of New York and elsewhere, the defendant, personally, or by acting in concert with another person or persons, made or caused a false entry in the business records of an enterprise, specifically, an invoice from Michael Cohen dated February 14, 2017, marked as a record of the Donald J. Trump Irrevocable Trust, and kept or maintained by the Trump Organization, and page 35-2. That the defendant did so with intent to defraud that included an intent to commit another crime or to aid or conceal the commission thereof. If you find the people have proven beyond a reasonable doubt each of those 2 elements, you must find the defendant guilty of this crime. If you find the people have not proven beyond a reasonable doubt either one or both of those 2 elements, you must find the defendants not guilty of this crime. You have now heard me define the law for count 1. There are 33 remaining counts in the indictment, each for falsifying business records in the first degree and each occurring in New York County. The only difference is that each count pertains to a different business record and possibly a different date. The underlying law applies in the same way to each of the remaining counts, so I will only repeat it in full one more time before I read count 34. Of course, you can ask me to repeat the law in its entirety as many times as you wish and I will be happy to do so. The second count pertains to an entry in the detailed general ledger for the Donald J. Trump Irrevocable Trust, dated February 14, 2017, bearing voucher number 842,457, and kept or maintained by the Trump Organization. The third count pertains to an entry in the detailed general ledger for the Donald J. Trump Irrevocable Trust, dated February 14, 2017, bearing voucher number 842,460, and kept or maintained by the Trump Organization. The fourth count pertains to a Donald J. Trump Irrevocable Trust account check and check stub dated February 14, 2017, bearing check number 000138, and kept or maintained by the Trump Organization. Page 36. The fifth count pertains to an invoice from Michael Cohen dated March 16, 2017, marked as a record of the Donald J. Trump Irrevocable Trust, and kept or maintained by the Trump Organization. The sixth count pertains to an entry in the detailed general ledger for the Donald J. Trump Irrevocable Trust, dated March 17, 2017, bearing voucher number 846,907, and kept or maintained by the Trump Organization. The seventh count pertains to a Donald J. Trump Irrevocable Trust account check and check stub dated March 17, 2017, bearing check number 000147, and kept or maintained by the Trump Organization. The eighth count pertains to an invoice from Michael Cohen dated April 13, 2017, marked as a record of Donald J. Trump, and kept or maintained by the Trump Organization. The ninth count pertains to an entry in the detailed general ledger for Donald J. Trump, dated June 19, 2017, bearing voucher number 858,770, and kept or maintained by the Trump Organization. The 10th count pertains to a Donald J. Trump account check and check stub dated June 19, 2017, bearing check number 002740, and kept or maintained by the Trump Organization. The 11th count pertains to an invoice from Michael Cohen dated May 22, 2017, marked as a record of Donald J. Trump, and kept or maintained by the Trump Organization. Page 37. The 12th count pertains to an entry in the detailed general ledger for Donald J. Trump, dated May 22, 2017, bearing voucher number 855,331, and kept or maintained by the Trump Organization. The 13th count pertains to a Donald J. Trump account check and check stub dated May 23, 2017, bearing check number 002700, and kept or maintained by the Trump Organization. The 14th count pertains to an invoice from Michael Cohen dated June 16, 2017, marked as a record of Donald J. Trump, and kept or maintained by the Trump Organization. The 15th count pertains to an entry in the detailed general ledger for Donald J. Trump, dated June 19, 2017, bearing voucher number 858,772, and kept or maintained by the Trump Organization. The 16th count pertains to a Donald J. Trump account check and check stub dated June 19, 2017, bearing check number 002741, and kept or maintained by the Trump Organization. The 17th count pertains to an invoice from Michael Cohen dated July 11, 2017, marked as a record of Donald J. Trump, and kept or maintained by the Trump Organization. The 18th count pertains to an entry in the detailed general ledger for Donald J. Trump, dated July 11, 2017, bearing voucher number 861,096, and kept or maintained by the Trump Organization. Page 38. The 19th count pertains to a Donald J. Trump account check and check stub dated July 11, 2017, bearing check number 002781, and kept or maintained by the Trump Organization. The 20th count pertains to an invoice from Michael Cohen dated August 1, 2017, marked as a record of Donald J. Trump, and kept or maintained by the Trump Organization. The 21st count pertains to an entry in the detailed general ledger for Donald J. Trump, dated August 1, 2017, bearing voucher number 863,641, and kept or maintained by the Trump Organization. The 22nd count pertains to a Donald J. Trump account check and check stub dated August 1, 2017, bearing check number 002821, and kept or maintained by the Trump Organization. The 23rd count pertains to an invoice from Michael Cohen dated September 11, 2017, marked as a record of Donald J. Trump, and kept or maintained by the Trump Organization. The 24th count pertains to an entry in the detailed general ledger for Donald J. Trump, dated September 11, 2017, bearing voucher number 868,174, and kept or maintained by the Trump Organization. The 25th count pertains to a Donald J. Trump account check and check stub dated September 12, 2017, bearing check number 002908, and kept or maintained by the Trump Organization. Page 39. The 26th count pertains to an invoice from Michael Cohen dated October 18, 2017, marked as a record of Donald J. Trump, and kept or maintained by the Trump Organization. The 27th count pertains to an entry in the detailed general ledger for Donald J. Trump, dated October 18, 2017, bearing voucher number 872,654, and kept or maintained by the Trump Organization. The 28th count pertains to a Donald J. Trump account check and check stub dated October 18, 2017, bearing check number 002944, and kept or maintained by the Trump Organization. The 29th count pertains to an invoice from Michael Cohen dated November 20, 2017, marked as a record of Donald J. Trump, and kept or maintained by the Trump Organization. The 30th count pertains to an entry in the detailed general ledger for Donald J. Trump, dated November 20, 2017, bearing voucher number 876,511, and kept or maintained by the Trump Organization. The 31st count pertains to a Donald J. Trump account check and check stub dated November 21, 2017, bearing check number 002980, and kept or maintained by the Trump Organization. The 32nd count pertains to an invoice from Michael Cohen dated December 1, 2017, marked as a record of Donald J. Trump, and kept or maintained by the Trump Organization. Page 40. The 33rd count pertains to an entry in the detailed general ledger for Donald J. Trump, dated December 1, 2017, bearing voucher number 877,785, and kept or maintained by the Trump Organization. The 34th count is also falsifying business records in the first degree, but as it pertains to a check and check stub dated December 5, 2017. I will now repeat for you the law pertaining to the crime of falsifying business records in the first degree in its entirety.
Okay. Falsifying business records in its entirety. New York. Didn't we read this already? Let's see. Let's 175-10 is here twice. Yes, we did in fact read it. It was at page 27 and then again at 40. So yeah, we're not going to do that again. We're not going to do that to you. But I would like to do the jury deliberation rules. I don't think we've covered that yet. So let's just do it. Let's just go for it. There's other voices we can listen to. I think Will is a little sassy. You know?
Jury deliberation rules. Finally, there are a few.
I don't like it. I don't like it. Bring back Sally. She's my girl.
Few remaining rules which you must observe during your deliberations. 1. While you are here in the courthouse, deliberating on the case, you will be kept together in the jury room. You may not leave the jury room during deliberations. Lunch will of course be provided. If you have a cell phone or other electronic device, please give it to a court officer to hold for you while you are engaged in deliberations. 2. You must deliberate about the case only when you are all gathered together in the jury room. You must not, for example, discuss the case as you go to and from the courtroom. It is important that each juror have the opportunity to hear whatever another juror has to say about the case, and that by law must only be done when you are all gathered together in the jury room. Thus, if for any reason, all 12 of you are not gathered together in the jury room, please stop deliberating until you are all present. 3. During your deliberations, you must discuss the case only among yourselves. You must not discuss the case with anyone else, including a court officer, or permit anyone other than a fellow juror to discuss the case in your presence. 4. If you have a question or request, you must communicate with me by writing a note, which you will give to a court officer to give to me. The law requires that you communicate with me in writing in part to make sure there are no misunderstandings. 5. We will work every day until about 4:30. However, we can work later if the jury wishes to do so and all the jurors are in agreement. Simply send me a note as early in the day as possible and let me know that you wish to stay beyond 4:30 and if so, what time you would like to work until. Depending on the time you select, we may order dinner for you. I should explain that, under law, I am not permitted to have a conversation about the facts of the case, or a possible verdict, or the vote of the jury on any count with any one juror, or group of jurors, or even all the jurors. Thus, in any note that you send me, do not tell me what the vote of the jury is on any count. If a juror wants to speak to me during deliberations, a meeting here in the courtroom with the parties will be arranged. No juror, however, can tell me what is being said about the facts of the case, or a possible verdict, or what the vote of any juror or the jury is on any count. And, while I will of course listen to whatever a juror has to say that does not involve those subjects, I may not be able to respond to that juror if the response involves instructions on the law. I may be required to call in to court the entire jury and respond by speaking to the entire jury. The reason for that is that our law wants to make sure that each and every juror hears, at exactly the same time, whatever I have to say about the law, and our law wants to make sure that the jury hears those instructions from me and not from another juror. That concludes my instructions on the law.
Okay. We just got it. We got the full rundown here. So, where are we, Inner City Press? Don't leave me hanging. I think he's just reading testimony back, is my impression of what's going on right now. Readbacks. Okay. So they're playing Pecker. And I don't know what I mean, I kind of know what the law is here. I want to, go ahead and read Inner City Press's book to you guys. I think streaming the straight audio book would be a violation of copyright. But I think I'm allowed to read it to you. But I wonder how long we're talking here. What is how many 111 pages. Chat, I gotta draw the line somewhere. Right? No, I have the Kindle points, but I don't have Kindle Unlimited, or I do have Kindle Unlimited. I don't know. Join Kindle Unlimited. Listen, if it's another step here, we're gonna have to. Oh, God damn it. You can't see where I live. All right. Well, don't swap me, I guess. now that everybody's thinking about it. I tried, chat. I was so close. Let me just bring that up to another place. Oh, man. Yep. We're going to use that address. We're so close here, gang. We're close. I already have a Kindle Unlimited membership. You can redeem this membership for an Amazon.com gift card on your account instead. I don't even understand what's going on here. All right. So, buy now, one click. Oh, God. Listen. We gave it the old classic. Yeah, I did. I 100% doxed myself, Stacy. Listen, it's not hard to find people these days. You can find me. But yeah, it really derailed my train of thought. I got to tell you. So my thought is it's coming up on 11 o'clock, and the jury is getting testimony read back. I'm thinking it's a good time to fill up the old coffee mug. Do you think they'll convict? I don't. I want to think no. I would like to think no. But there's, if they don't get them on the falsifying business records, could they get them on the tax stuff? I don't know. It's hard to know what people will do. It's just like what they say is basically ask the first 10, 12 people that walk into your grocery store what they think, and that's, what the jury's going to think. It's just a random selection of people, completely, it's hard to tell. But there are people out there that make a good living, doing the guesswork. Let's give Biden another 4 years. Can't be real. Which proves they convict. Which they will, this is total insanity. I hope there's one person with a brain on that jury. There's gotta be. There's gotta be. Just a whole lot of balls. Yes. Agreed. Agreed. All right. So, do you think that the jurors are worried about their own safety if they don't convict him? Interesting. You know what? These are New York City jurors. I think they're worried about their own safety every day, day in and day out anyway. I flew out of JFK recently. No, I take that back. I traveled to Grand Central to Newark, flew out of Newark. But just in that time where the train pulled into Grand Central and I had to make my way to Newark, Grand Central to the Uber, basically. In the past, I have done that trip, Grand Central to Penn Station to Newark. You can walk from Grand Central to Penn Station, no problem. But I'm not taking the risk these days. It seems like the insane asylum's like an open air insane asylum is what it seems like to me. I'd be scared to find him scared to not find him guilty. I don't know either. Which way does the wind blow there up in New York City? People have always been insistent that it's a very liberal city. And yeah, I guess that's probably true to some extent. But I also think that, Republicans and conservatives don't get any oxygen, right? It's just all sucked up out of the room. I don't even know if it's as liberal as they want us to believe. And the reason is, it's famously corrupt there. So if there is some sort of election tampering, which let's to put it in the government's own terms, elections are like a quilt patchwork. Every state, every county, municipality does it a little bit differently for the most part, and so you have so many different ways. It's like a quilt. That's what they said 10 years ago. But quilts are they're not security it's very easy to, they get tattered. And there's definitely vulnerabilities. You can't say there's no vulnerabilities anywhere. There's no election fraud anywhere. That's a line that doesn't hold any water. The argument's built on sand. We can see it with our own two eyes. At the very least, people harvesting ballots and stuffing ballot boxes. At the very least. So, I don't know. Where was I going with that rant? New York City. If there is corruption and tampering, I believe New York City is one of the places that it happens. How's that? Oh, what is he guilty of? Not to mention the statute of limitations is up, so there shouldn't even be a case. Yeah, I agree. And especially when man. I am a real lawyer. It depends. I can't practice everywhere. A lot of people think, you're a lawyer, you can practice anywhere. But right now, I'm a newer lawyer, and in 3 to 5 years, I'll have like reciprocity across 30-something states. But right now, I'm really just practicing in one state, and then there's 3 or 4 federal admissions. I'm pro hoc vice in the Southern District of Texas. Puerto Rico, I'm admitted to practice the federal court of Puerto Rico. Or it being, so I am a real lawyer. Yeah. Sometimes it doesn't feel like it. I'm just kidding. Law has changed a lot in the past few years. I mean, you've seen the two-tier justice system. It doesn't just happen with Trump. It happens. I'm sure you see it happening at the local levels too. The political class, if they're on the inside, then their problems go away. Where I live, you had a county commissioner crash into a tree. It was a clear and obvious DUI. Nothing really ever came of that one. You had another county commissioner who was caught on camera stealing a bougainvillea plant, which is very embarrassing. And nothing ever came of that one. Now, if you and I got into a DUI or was on camera stealing a bougainvillea, I'd expect them to bring charges against you and me. So, what's the hardest law to study? Tax law was tough for me. Tax law was tough. And then, there's the courses where you're at odds with your professor. There are professors who think of the Constitution in a very different way. I am someone who thinks the Constitution is not a living document. It is dead. All right? It is as dead as the paper that it's written on, and the founders meant what they meant, and they didn't mean what they didn't mean. Now you can have a constitutional law professor who's like, it's a living document, and everything is changing, every year, and it mostly, views the Constitution through the lens of, let's just say, the LGBT community, and that's what all the rights are about. And then every chance that professor gets, when I was in law school, Trump was president, and he would mutter under his breath about, Trump. And then, rah, 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 rah. The Constitution's a living document. So that class was tough for me because I was one of the only students who would ever challenge the professors, basically. And it's not always fair. They will, when it comes time to grading, they remember. And I think, it's supposed to be confidential grading finals, and I feel like it's not. I feel like it's not. So what do we have, Stacy? Play car got stolen. Play car got stolen. The guy who stole it was found in my car. My car was taken away from me for 3 months because it was evidence. I run a business, and that hurt a lot. He was never convicted. Ugh. Talk to text did me dirty. Don't worry. I think you meant my car. Yeah. That's unfortunate. And I don't want to say that you haven't been proactive, but if you can, shake the trees a little bit. If you haven't gotten it back, gosh, you got to get that back. You have it back yet? That's too bad. I'm sorry, Stacy. It's all kangaroo court in Arizona, that's for sure. It's been an eye-opening experience for my fiance and I. It just doesn't feel like America anymore. Because he's having to campaign on top of going to all these BS court cases. He's probably barely has any time to sleep whatsoever. Yeah, I agree. And not to mention the stress of all these cases. Listen, when the federal government or the state government is barreling down on you with all of their resources, they're not sparing any resources here, It is intimidating, and it is hard to fund, too. It's draining. Completely draining. Can you imagine just a couple of charges? A couple of charges could completely empty everything that you ever saved. And then, 90-something fabricated things, sham trials, 3 or 4. I wonder what the cost is to Trump and the cost to the taxpayer is, because it's probably out of this world. Oh my God, can you imagine if you pulled the smoke alarm? See, that's exactly what I'm talking. It's I forget, Bowman. I don't know the guy, but pulled to prevent a vote or discussion or something. He pulled the fire alarm in the House. It couldn't have been no senator would do that. That is a move from the House. Oh, yeah. We should get back to Inner City Press and see what he's doing. So, it looks like they may still be reading back some testimony. Yeah. Listen, chat, I have to get more coffee. I gotta get more coffee. So, I'll probably go and come back Couldn't read the warning sign. No, I think it was a congressman. House, those are called representatives. They're all technically congressmen, but the House is typically what people refer to when they say congressman, someone in the House, a representative, and then the Senate, they're senators. But technically, can you get me some coffee, Candace? I know. I would love to. This is as good a place to end it for now. It's 11 o'clock. I don't think we're going to be getting any verdict before 12. But if there is, we'll be back. We'll be back after lunch for sure. Thank you for joining. And remember, I always say knowledge is power. Subscribe for more chat. I love you. Couldn't do this without you. I look forward to it. All right. Oh yeah, it's not necessarily 11 o'clock where y'all at, but where I am it is. I doxed myself. Go back and check.